after he came in voluntarily to explain his story. We did not subpoena him. When he came in, we asked would he have a full meeting. He then had a full access of the ranking member staff, his Democratic staff.
On the 4th of July.
What day was it? On the 4th of July, both majority and minority.
And when he was with you, when he voluntarily came in, was he sworn?
No, he was not.
Thank you for you.
But he was sworn. Okay, it's a false statement. You can't lie to staff. I'm being told he would be under the same criminal allegations, as you know, if you give false statement to members of Congress. But just so we understand, and I want to make sure that you get something, there's another individual whose name hasn't been mentioned here that we would have on the same panel, several others. Jason Weinstein, Kenneth Melson, and Patrick Cunningham, and Hurley, for example. These are all people that I know the ranking member would like to have. We would like to have them. But from a deposition or an interview done on a bipartisan basis with Jason Weinstein, we were told in that, and this is one of the reasons we're here today, we were told about a document that Jason Weinstein had prepared, and he said, my recollection, it's been a long time, that it was 3 or 4 pages, and it was an analysis of the case reflecting that he had interviewed Cunningham, Hurley, and then walked through the case and how it went about and issues with the case. Okay? He's talking about a 4-page memo that he wrote as an email. In the weeks after February 4th, he conducted this. So Weinstein says in this interview, okay, I didn't write the memo. I wrote an email summarizing what those gentlemen told me. Okay? Investigator says, okay, what did that email say? DOJ attorneys, our attorneys of justice said, he can't answer that question. Weinstein, okay, it was after February 4th. Investigator, okay, so you're not going to answer my question? DOJ attorney interrupting, he can't. Weinstein, as I said, I can't. That memo, 4 pages, prepared shortly after February 4th, when we were saying this is an outright lie, we were saying something's inherently wrong with this. We have a whistleblower saying there's gun walking. They dispatch one of the top people. He does a quick investigation. He produces a memo. He wants to testify to it. DOJ says don't talk, don't answer their questions. In other words, they obstructed right in front of us. We're asking for that document. Right. Now, that document's not all that deliberative.
Just go back to the ATF. So you didn't have the ATF. You didn't have the ATF officials in a hearing because you were concerned about grandstanding. Is that why? Is that what you said? I mean, that's the new definition of irony. Well, I'm just repeating what you said to me. That you know,
look, we had Phoenix-based ATF agents available. This gentleman from Washington has testified, and we would have him back again. But we are not easily going to have somebody back again when there are documents that are being withheld that would allow for a sensible set of questions. Again, there's no reason to have somebody in 5 or 6 times when the people who could allow you to have it in are denying us the documents. We have no problem with having Kenneth Melson back in. We're certainly willing to. But again, he's told us things that exist. We're asking for those things, and we're being told we can't have them.
It's been what, a week since you reported this contempt resolution out of your committee? I mean, what is the rush to bring this to the House floor? I mean, we have an emergency meeting here in the Rules. We have an emergency meeting here in the Rules Committee. Minority staff on the committee have found in a few short days that the report has been made available. They've found 100 concerns with the majority report, and I think we all, I don't care. What party we're with. Well, I think we're all interested in making sure that whatever comes to the floor represents accurate information. And the minority staff has found 100 areas in the report in which they raise concerns about whether they're factual, or they're accurate. And again, given the fact that the Democrats have been denied again and again the opportunity to call witnesses, I think it's incumbent upon the Rules Committee, I think it's incumbent upon the Speaker, to approach this in a more rational way. Let me ask, I'll ask Mr. Cummings, this is on page 22 of the report, the contempt citation says, and I quote, "Because the Department has not cited any legal authority as the basis for withholding documents pursuant to the subpoena, its efforts to accommodate the committee's constitutional obligation to conduct oversight of the executive branch are incomplete." Is that an accurate?
Well, it disregards the fact that the Department repeatedly cited the executive branch concerns and its legal authorities in numerous letters to the Chairman. I mean, whenever something came up, they made it clear as to why they were not able to do it, and cited legal authority.
Again, I'm just puzzled that we're doing this contempt resolution, and the head of the ATF has not testified publicly before the committee. It would just seem to me that it would be we would want to hear his testimony before this thing comes to the floor. I mean, this is a terrible tragedy happening, and what I see happening is you're compounding that tragedy. I really do agree with Ranking Member Slaughter. I mean, this looks like and smells like a witch hunt to me. I mean,
well, that's been the Democratic talking points all along.
This is. I mean, as I get deeper and deeper into this, and I learn about all the documents that have been released, and I learn about the willingness of the Justice Department to continue to cooperate. I mean, this idea that we're in the Rules Committee with an emergency meeting to rush this to the floor tomorrow just doesn't smell right to me.
Well, Mr. McGovern, as late as yesterday, the Attorney General Attorney General's folks presented even more documents to Mr. Boehner's staff, Ms. Issa's staff, and my staff. Again, trying to come to some type of agreement so that he could accommodate us and so that we could get what we wanted. I think basically the Attorney General has just come to a point where, he's saying, well, where does this end? He's not asked for an end to the investigation. He's just trying to say, okay, what am I going to?
I think what he's trying to figure out is whether to keep on moving the goalposts.
Yeah, right. Not keep moving the goalposts, moving the stadium.
Right.
We keep moving the goalposts closer, and he can't seem to kick a 2-yard field goal.
Well, you know what? I mean, again,
we could lower it down so he could walk over
I think
it.
what is happening here today is divisive, and I think it's destructive. I don't think this is about truth to justice. It's about politics, and I think it's a cynical maneuver, and I think it is a disservice to this institution and a disservice to the American people. We're all interested in the truth, and I think we're getting to the truth about what happened and what this botched, this botched ATF mission, which, I think we all have anger over these gun walking programs, and that's one thing. But what we're doing here today is going way beyond that, and again, I'll say it again. I think we're doing a disservice to this institution. I hope the Speaker of the House reads your letter very carefully, Mr. Cummings, and I hope and I never thought I'd say this, but I mean Newt Gingrich had a right when he intervened when Mr. Burton tried to do something similar. I hope Speaker Boehner does the right thing, and and we try to figure out a way to get to an accommodation rather than to this confrontation, which I think is a horrible precedent.
Thank you, Mr. Chairman. Thank you both for being here. I'd like to read a brief prepared statement, Mr. Chairman. What we're doing here today is protecting the Constitution of the United States of America, which all of us are pleased when we come here to raise our hand and swear so to do. It is critically important that we protect the powers of Congress of the United States for future generations. It would be dreadful if a future president, having looked back over the recent events, used it as precedent. We have a strong case on the merits, is the first point I want to make. We win the executive privilege argument, both on legal grounds and our compelling need for the requested information. Aside from prevailing on the merits of the executive privilege dispute, enforcing our subpoenas is part and parcel of our ability to perform effective oversight. If we accept the White House stonewalling in this instance, the House in the future will not be able to conduct its oversight. And every future president can view Congress not as a co-equal branch of this government, but as a subordinate to the executive. If we countenance a process where subpoenas can be readily ignored, where privilege can be asserted on the thinnest of reeds in the broadest possible manner, then we have already lost, and we may be in much more danger than even we believe. Mr. Chairman, that prepared statement is not my words. It's the words of the ranking member when she stood on the floor of the House on February 14th, 2008, in the last contempt process this House went through. And I think her words were as true then as they are today. It is beyond me how this has become a partisan discussion and a discussion about the merits of an investigation and not a discussion about whether a co-equal branch of government is responsible to accede to our subpoena power. And I'd be happy to yield to my friend.
I appreciate it because I see this as entirely different. What we have here, in my view, let me make it clear, this is my opinion, was not an attempt to find out what happened so that Brian Terry's parents could have some idea of what happened to him. It was a way that we could get to the Justice Department and through him to the President of the United States. If you had wanted to do a serious investigation, I don't think there's any question, and I don't know how anybody in the world could even give pause to the notion that you would certainly have had the ATF in there publicly. You would have had the people who headed up the Phoenix station in there to find out what happened. You would want to know what went on previously, but there's none of that. That was just all jumped over. And not a single Democrat witness was allowed to speak at any of those meetings that they held. I can't seriously take that. I'm sorry.
I would say to the gentlelady that
I know Mr. Issa works very hard, and I know how dedicated he is. But I don't believe this could ever masquerade under the guise of any kind of serious investigation to find out what happened here. You haven't talked to the people who were responsible for it.
I would say to the gentlelady
then don't come to Rules Committee.
that this is not a Rules Committee meeting on the merits of this investigation. This is a Rules Committee meeting on a contempt resolution when a member of the executive branch is not responding to a duly issued subpoena. And I would say, because you and I have not studied these issues, I would say to my friend, Mr. Cummings, I understand all of your complaints about the way things have been handled over the last 16, 18 months. If I'm ever in the minority, I'm going to have some complaints about the way things are being handled too. But my question to you is there one document that a duly issued House subpoena has asked for that the Attorney General could produce today, but he has as of yet been unwilling to do it? Is there one?
I'm sure there may be, but let me just try to, wait a minute, hold on.
I'll come back to that.
Let me answer your question.
I'll absolutely, having answered.
Because I want to be real clear
Right.
with you. I don't want you to do what
question.
happens in our committee.
Right,
I want to be able to answer the question.
I'd love to find out. They put us here on this committee of exclusive jurisdiction. You better believe I'd love to be over there serving.
And by the way, I can answer that question if you'd like.
But if there is one, my question is, why aren't you, as a member of this body, as am I, why aren't you in strong support of having the executive branch respond to our duly issued subpoena? This is not about trying to embarrass the Attorney General. This is not about trying to pivot a Republican group against a Democratic group. This is about trying to defend the rights and privileges that the people of the United States have entrusted to us, and the gentlelady was absolutely right in 2008. If you allow Republicans to go easy on Republicans, the Republic suffers. And if you allow Democrats to go easy on Democrats, the Republic suffers. We are not sent here to be Republicans and Democrats. We are sent here to be stewards of the United States Constitution. And I ask you sincerely, if this is a duly issued subpoena, you may wish it hadn't been issued. You may not like the circumstances under which it was issued. But if it is a lawfully issued subpoena, why aren't you standing here in strong support?
Because I'll answer that. It's not a question of standing in strong support or not. I said to Mr. Issa, and I've said it over again, when I became the ranking member, I wanted our committee to operate just a bit lower than a federal court. I wanted to have integrity. I wanted to have fairness. I wanted, when something came out of this committee, for people to feel comfortable with it. That's what I wanted. I have not seen that. Now, I have been consistent. When I've joined Chairman Issa with regard to subpoenas. Most subpoenas we found out about after the fact now, by the way. And I have no problem with that. But there's another piece of that. I want this institution to be strong. I also want the executive branch to be strong. That's part of our duty, too. When I see accommodation, when I see the Attorney General trying to work with us, don't keep in mind, it's not somebody saying, I'm absolutely not going to do what you've asked me to do. He's produced 7,600 documents, gone through millions of emails, appeared 9 times before the Congress of the United States, ordered IG investigation, done all kinds of stuff. And all I'm saying is that we are very close to being able to maintain the integrity of both institutions. That's what it calls for. The Constitution calls for an accommodation of each other and respect of each other. And so I don't think that what the Attorney General has asked for, that is us to continue to try to work this thing out, is undue. Nor do I think much of what Mr. Issa Chairman Issa has asked for is too far out. What I'm saying, though, is that there's a way that reasonable persons should be able to agree to get this done. It's not my way or the highway. That's not how we operate.
I couldn't agree with the gentleman more.
And just one other thing. Keep in mind what I said a little bit earlier, and I think you'll really respect this from what you just said. 1,300 documents were given over and above what was even asked for. And the Attorney General said, I'm willing to give these other documents to you, and more than what you've asked for. All I'm asking for is some respect with regard to this contempt situation. That's all he's asked for. And asked for a good faith effort to bring it to a resolution. And all I'm saying is, I think that what we're doing here, we're gonna find in contempt the highest ranking law enforcement officer in the country, when there has been an effort to work with the Congress. That concerns me. I just think, again, keep in mind, in the past 6 months in the Myers case, with the U.S. Attorney firings, 6 months elapsed between the time we voted contempt out of the committee and the time that it went to the floor. 6 months. This is a matter of a few days. And I'm just saying, I just think that when you consider what we're dealing with here today, the fact that the Attorney General has done what he's already done and willing to do more as late as yesterday, I just think that this is just a bit much for that. And I think it deserves a little bit more time, that's all.
Yeah.
Mr. Woodall, to answer your question, yesterday, representatives, including of the Speaker's office, joined with my staff, and we went to the White House. We were told that they wanted to try to bring this to a successful close, and they implied there'd be something new. What was new was there were approximately 30 pages of selected documents from what we now understand to be about 200 pages that would be a complete and total, if you will, end of this case. The quid pro quo that has been repeatedly offered is that this has to satisfy subpoenas. The documents which were quickly briefed and shown in front of our people, they were not allowed, they had to put their notebooks down, they weren't even allowed to take notes about what they were being shown, included, apparently, from what the briefing said and our folks quickly were able to glance at, the Weinstein memo of 3 to 4 pages, something that undeniably is responsive and does not fall within any reasonable, because remember, they were investigating a false statement to Congress. They were interviewing the people responsible for the false statement, including people that we have had before our committee. That document was not available unless we took the deal. On the Speaker's staff's part and ours, we mutually agreed that there was no deal possible because it was a deal without sufficient documents to answer the important questions that clearly were still there.
I just want to make sure I understand you, Mr. Chairman, because I know Mr. Cummings was laying out a very persuasive case for how accommodating the office, the Attorney General, had been in trying to work with you. You're saying that the information that you have been seeking, they had there for the first time that you had ever seen it, and they, rather than giving it to you, they said, we will only give it to you if you agree to all of these preconditions?
That's the deal.
About giving it to you?
That's the deal. And ultimately, I know the ranking member characterizes 7,600 documents as a lot, or 7,600 pages, I should say. Many of those pages were blacked out. I have a hard time counting anything in which it is completely obstructed as counting. So you take hundreds of pages off for that. Almost 2,000 of them were related to wide receiver. Fell within our subpoena because we wanted to know about gun walking, and wide receiver, we would certainly say, was a failed program of what we would call bad controlled delivery or gun walking. No question. But when you actually look at Fast and Furious, you're now down to a few thousand documents out of 140,000 documents by, or pages probably, by the Attorney General's own statement, 80,000 given to the Inspectors General. The point, though, is the documents we have been given have been selected by, and it's less than 10% of the responsive documents, by the Attorney General's people, and they've given it to us. Quite frankly, they've given us documents that disproportionately prove their case. Now, I don't want to raise the stakes artificially high, but if we had finished Nixon at 10% of what he wanted to give us, we would still have had Nixon serving out his term. If we had taken 10% of Iran-Contra, we wouldn't know how foolish and failed that program was. At the end of the day, Congress has an obligation to understand the documents they want to give you and the documents they would love to see burned in a pit somewhere. We have an obligation to, at least on an in-camera basis, review them. We have tried to work, and the ranking member mentions this, we've tried to have accommodations. We've said, give us a privilege log. Show us what you're not giving us by description, so that at least we can know it exists, and then we can have a discussion about whether or not it falls under privilege. They've refused to do that, and that's part of the problem, is you can't end a discussion based on, we've given you what is responsive. They've given us what shows their side of the story. We need to see both sides, at least in camera.
Mr. Woodall?
Yes, sir.
May have a breakthrough here. I'm not sure. You know what a privilege log is? Yes, sir. A lot of this research hasn't even been done yet. And, of course, with the privilege log, you've got to identify the documents you're not giving, and then describe them, and then tell why you're not giving them up. Is that a fair description?
That's a fair description.
Fine.
And the Attorney General said he'd identified all the documents in live testimony before judiciary.
And so it's my understanding that that would take some time to do that. I mean, it's my understanding. Again, I wasn't there, so I don't know. But I'm hoping that maybe you see, we're not that far apart, is what I'm saying. And I think this is a very, when you're going to find somebody in contempt, and it's the only cabinet member in the history of the country to be found in contempt, it seems as if we should be able to work something like this out.
The gentleman,
I'd be happy to yield to my friend.
I just find all this very fascinating. Mr. Issa said that he wasn't calling for the Attorney General's resignation, then he invokes Richard Nixon. But putting that aside, I just want to say one thing.
The similarity is undeniable.
I want to say one thing here, and that is that is apropos to this committee. And that is, we're the process committee, and process matters. And when the process is flawed, I think it's flawed in your committee, Mr. Issa, the fact that Democrats were locked out, shut out in terms of being able to have any witnesses. That's a flawed process by any measure. I don't know of any other committee that can boast that. But the fact that we're here under an emergency meeting, that this has to be done like right this second, tomorrow, because it is absolutely so vital.
We're claiming my time on that point. We're claiming my time on that point from my friend, because he raises a very interesting point. As the gentleman well knows, we could have called this meeting last week. Most bills don't sit for 6 months, as the gentleman explained on a contempt resolution from 2008. They get reported out of committee at night, and they show up here the very next morning. But in this case, the chairman of the committee said, I don't want to bring it to this. No. I don't want to bring it to this. Let's not drive this train. Let's wait.
Well, the gentleman,
let's wait.
The factual,
be happy to yield.
Yeah, one of the resolutions that we're considering, we didn't get until yesterday. Last night. So when, all this time that the gentleman is saying has elapsed, one of the resolutions we didn't get until last night. So I mean, we are rushing this, and I don't know what the emergency is. Let's see where we can work this out, avoid this kind of terrible confrontation, because quite frankly, the process is flawed, and that's why people like myself question what the real motivations are here.
You would think you could work something like this out. I'd ask you, Mr. Cummings. I mean, we're talking about a memo. The chairman's reading the testimony, disclosing the memo. He's reading the notes where the attorneys won't let him discuss the memo. He's down there in a meeting with the White House yesterday where they're practically waving the memo in his face and saying, but I'm not going to give it to you unless you agree to my terms and conditions. Treating this with that kind of cavalierness, I find troubling. And I would ask you, we ought to be able to find that accommodation. I mean, have you asked the Attorney General to be compliant with this subpoena from Congress?
I have, where we are now, I mean, recently? Are you talking about recently, sir?
Well, I guess I had in my head that if you'd asked him in the beginning, he would have done it. And because he didn't.
Yes, we have. I've also sat in the meeting where, and again, I want to emphasize, again, I wasn't in the meeting yesterday with the staff folks, whatever, but the meeting I was in, he just asked for one thing, a good faith effort to bring this contempt situation to some type of conclusion.
But how do we do that when they have the documents the Congress is asking for and they say, we'll only give them to you if? That is not how you respond to a subpoena. You respond to a subpoena with production of the documents. And I'm sympathetic to what you're saying. I'm thankful now that I received the assignment on the Rules Committee instead of the Oversight Committee as I originally requested. Because
and if you were on my side, you'd really be glad you were over here.
How do you respond to that? As you were telling the tale earlier about how many documents there were and how long it takes to compile them and who knows and when they knew and how difficult it is to put all that together, I was persuaded. When the chairman tells me that he was standing there in the presence of the memo and folks dangled it and yanked it back, I find that troubling.
Well, the chairman wasn't there. His staff was there. He wasn't there.
As he relates the story.
No, but again,
do you find that troubling, Mr. Cummings?
First of all, I don't think anybody was dangling anything. I think basically what they were trying to do was trying I've been in the meeting with the Attorney General and with the chairman, and I watched him. And he basically was almost pleading to, let's try to work this out. And he explained as best he could, that he was concerned about certain documents because they were a part of the deliberations within his organization. He used the words that revealing certain documents would have a chilling effect. This is the internal documents. Now, I don't know what the documents were yesterday. And he said it would stand in the way of folks being able to have dialogue amongst the members of staff. And these are, by the way, these internal deliberative documents are documents that have time and time again come under assertions of executive privilege.
These kind of documents have been found not to be covered by executive privilege.
I didn't see the documents, so he didn't see them either. So, again, I still say that if we are going to find the first cabinet member in history in contempt, we should be able, as reasonable people, to get this thing resolved. That's why I asked Mr. Boehner. I believe that if Mr. Boehner got personally and directly involved in this, I believe that we could work this out.
Given the trust deficit of government among the American people today, I would argue there is no more important committee on Capitol Hill than yours.
And Mr. Woodall,
yes, sir.
Let me say something to you, sir. I agree with you. I agree with you, and that's why I have argued, many times about the integrity of this organization. That's why I have done it over and over again. That's why I've said don't go out making accusations and then looking for the facts. I believe in integrity. It is very important to me. I live by it. I practice it as a lawyer, and I believe in it. And I believe that when you put out a product, it should be a product that people can believe in. And I think that if we take this Attorney General and find him in contempt tomorrow, I'm telling you, I think that it's a stain on us as an institution. particularly when there is an effort to work things out?
We have 24 hours, and I would urge you with all my mind. I don't think he'll take my phone call, but he'll take yours. And I would urge you to do what you can to have those documents produced by tomorrow, because I don't think there's a one of us here who's going to take pleasure in that vote.
Thank you.
I yield back, Mr. Chairman.
Thank you very much, Mr. Chairman. Mr. Chairman, I'd like to begin my remarks by making it very clear, adopting yours, Dr. Fox's, Mrs. Slaughter's, and Jim McGovern's, and Mr. Woodall's comments and echoing them, and knowing that Mr. Cummings and Mr. Issa and their staff carry the gravity of the circumstances giving rise to Agent Terry's death. And all of us in this institution owe answers and the deepest kinds of apologies that could be offered, bipartisan or partisan, or to Brian Terry's family. It should not go unnoticed what Mr. Cummings said regarding the fact that he reached out immediately once he learned of the circumstances, a week after his nephew had been killed in a firearms situation. These are not comfortable times in our country. And this is not a comfortable exercise for our country. Being older than most of you, Mrs. Slaughter and I, and Chairman Dreyer, and you, Mr. Chairman, have participated in all of the recent situations dealing with contempt. In the matter pertaining to Attorney General Janet Reno, it has been mentioned that when a good friend of mine, Dan Burden, brought the matter out of his committee, yet another person that I know well and have great respect for, certainly his intellect and his understandings of the history of this institution. Then Speaker Gingrich saw fit not to put that matter on the floor of the House of Representatives. In the matter of Jim Watt, John Bolton, Harriet Myers, entirely different propositions. And to answer my good friend from Georgia, Mr. Woodall, who asserts correctly that we are here to protect the Constitution, the simple fact of the matter is executive privilege is also a constitutionally protected part of our enormously endowed our government's all three branches. We're on the cusp of a historic precedent coming from our United States Supreme Court, regardless of their findings, or more than likely on tomorrow. And here we are with the time period spending that I believe that we will correct about student loans in this country. Here we are today discussing contempt. Our transportation infrastructure in this country is seriously in need of repair. And here we are talking about contempt. We need jobs desperately in this country. I read a statistic yesterday that said that 56% of children that graduate, or people that graduate from law school, cannot get a job. And here we are talking about contempt. I said to the fine young staffers that worked with me when I learned that we were going to do this, that I felt it was contemptuous for us to even be considering contempt. Now, let me tell you why. Chairman Issa, do you know who approved Fast and Furious?
The approving officer was Lanny Brewer. However, there's no evidence that he personally signed the OCDEF. They're normally delegated down to a regional level.
The approving officer, what position did Lanny Brewer hold?
He was the head of the criminal division, the number 3 of justice.
At the United States Justice Department?
That's correct.
Who?
But again, that is normally delegated down as probably as low as, at the time of the OCDEF forming, Cunningham and Dennis Burke would have been people who were clearly involved, but may or may not have gone all the way up there. And this is not uncommon. This is one of the challenges in OCDEF, and it's something I know you have a history looking at these various things for many, many years here in the Congress. All kinds of agencies feed into it: ATF, Justice, DEA, ICE agents, and yet the actual accountability typically tends to be, for all practical purposes, a U.S. attorney.
How do you characterize Bill Newell?
Well, we had him before our committee. He was one of those people who testified live, and we would say that he certainly was a responsible individual involved in.
Was he a rogue?
Yeah. No, I don't think a rogue is as accurate as this. He was, in my opinion, and I think the committee's opinion, an advocate, if you will. And this is one of the problems: is the advocates for these kinds of big wins, these kinds of big programs, existed and continue to exist within ATF and other agencies of the government. That's part of I think the most important part of why we take seriously the political appointees and the supervisors placed over these individuals. Is they're part of that check and balance.
Agreed. Mr. Issa, you and I served for a number of years on the Select Committee on Intelligence.
Yes, sir.
And I heard you a moment ago, and I'm going to come back, Mr. Cummings, and ask you to, if you would, after this question, respond to the initial question that I asked Mr. Issa and his offerings to that question with his answers. But I just want to make it very clear that I believe you know that there are many times in the executive branch when documents are redacted, and you spoke of when you saw some papers, I don't know where it was or when it was, that they were blocked out, were your words here today. And I do know for a fact not anything at all about those papers. And I want to put my bona fides on the table here. I've not spoken with Mr. Cummings about this matter. I've not spoken with you about it or any member of your respective staffs. I've not talked to the Attorney General of the United States about this matter, nor any of his staff, nor have I talked to the President of the United States of America or any of their staff, and I have not talked with any of the leadership of the Democratic Party to get any talking orders from anybody. Where I'm coming from is from the heart in my head and experience in this matter. And there are times, because of confidential informants, there are times, because of wiretaps, and I want you to just put a tack in that word, wiretap, and I'll be right back to it after Mr. Cummings answers the question that I asked initially.
It's my understanding, and from all our research and the documents we've gotten, Mr. Hastings, that this investigation was designed and implemented by the Phoenix office. Now, you asked about Mr. Newell. It's a fact that Mr. Newell was a part of all these operations. All right? I mean, he was rogue. There's no ands, ifs, or buts about it. And that's what I got from looking at the documents.
I appreciate it. Mr. Issa, your committee and or your staff received information from whistleblowers. Am I correct?
That's correct.
Did any of those whistleblowers offer up to you information that you learned after you received it, or that involved wiretap information?
Yes, sir.
Did either you or your committee pause at that time to question whether or not you should even have access without the approval of the judicial branch of wiretap information?
Well, I think, Mr. Hastings, the answer would be that my professional staff and I reviewed the question of whether or not we could open and look at these sealed documents. We believe strongly that the seal is there to protect, as it should be, by a Federal judge, to protect against a disclosure that could compromise the ongoing investigation. Wiretaps have a life of their own, and when they're over, they're over. We could have moved to have them unsealed, and then we could have made them more wide.
Sealed?
They were sealed. They are sealed. We did
By
by a Federal judge.
district court judge?
That's correct, and as they had been for a long
And you
period of time.
didn't feel uncomfortable or going forward and saying, hold on, let's go to Your Honor or His Honor and ask for permission to go forward with that information?
As you know, these wiretaps documents can be viewed by hundreds of people throughout justice. The question is, on a sealed document, is my understanding, and unlike you, I'm not a trained lawyer.
I have managed a substantial number of wiretaps.
Right. Those wiretaps, it is about whether or not they get disclosed to individuals that would be detrimental to the reason they were sealed. Congress has a right and a need to know, so after evaluation, we made a determination to read them, to understand them. We already had been told by an ATF agent a summary of what he believed they said as far as the gun walking. We have maintained them closely held, and this is something I think the ranking member and I are very proud of. There are only 2 copies. Ranking member has a copy, I have a copy. They're kept in safes. We've maintained the spirit and the fact of these sealed documents. We have not published them. We will not publish them, and they are for eyes only of members of Congress. They think that's appropriate based on separation of power.
Therein lies a part of the problem, Mr. Issa, and that is one thing that you and I and everybody that works inside the Beltway knows is that eventually matters that are purportedly secret will reach the public realm. But beyond that, when the whistleblowers, in my view, provided you with wiretap applications, I believe that the Department of Justice may have been prohibited by law from producing them. Thus, some of the documents that you are speaking to, I would ask Mr. Cummings whether or not you feel that some of those documents are prohibited or to be allowed to either your committee or in any way into the public realm.
I was very concerned, still am very concerned about it. As a matter of fact, Mr. Hastings, when we were sent these documents, first of all, we made sure that they were limited to just 1 or 2 people on my staff, because I just felt so uncomfortable with them. And one of the suggestions that I made in letter form to the chairman is that we go to the judge and find out from the judge.
You have a letter to that effect to Chairman Issa?
Yes, I do. And because I thought as an officer of the court, sealed document, criminal penalty of 5 years. I had a lot of concerns.
Yeah, well, you all are walking on very thin ice when you receive information from anybody that is under the aegis of a Title III wiretap. And I would urge the staff of your respective committees, ranking and majority, to review that information very, very carefully. Mr. Issa, I want to return to the 2-day interview. Who was interviewed?
If you're talking about the 4th and 5th of July.
3rd and
Or-
4th of July.
3rd and 4th? Make sure I've got my right. Okay, Kenneth Melson.
Kenneth Melson was interviewed. All right. And during that period of time, I asked you previously, and I ask you again, on the day that you say he voluntarily came in, was he placed under oath?
I believe the answer is no. No, he wasn't sworn.
And then how was Mr. Cummings or his staff notified that there would be a second day of interviews?
The gentleman behind me informed his staff after he came in and gave us voluntary statements. And Mr. Hastings, I want to make it very clear. This is a gentleman who you can't have it both ways, and it's not part of today's contempt, but I'll be full about it. You can't say, well, he said under penalty of criminal charges that he didn't know anything about it until he read the wiretaps, and then say, but we have to have him before we can consider contempt as to the withholding of documents from February 4th on. The two really are very different. We believe that his failure to do his job is part of the problem of acting people in that ATF position, which, by the way, on a bipartisan basis, Congress has failed to make sure that we have confirmed directors. And it's a problem. And I think that's one of the points of our committee. When this is all over and we get done with the dust-up here, getting ATF integrated in a way in which all of us can trust them as a law enforcement agency with confirmed and consistent leadership the way the FBI and others have is, in fact, one of the areas that our committee doesn't have a disagreement on.
Mr. Issa, you know, you and I stood up a whole other committee to oversee the stovepiping that was going on in the various intelligence committees. I wish you luck with the ATF code.
I know. We didn't do that well on the other one, but hopefully we can learn from it.
Mike Rogers and I had settled concerns at the time and still do. But going back to this gentleman, Mr. Melson, didn't he tell you that he didn't tell anyone at the Justice Department about the gun walking, and he's the guy you just referred to that said that he was sick to his stomach when he learned about it? Am I correct in that regard? And that would have been on the second day when he was under oath, or did he tell you that both days?
I think he told both days. And again, this was staff-led, so I wasn't personally present.
Therein lies yet another part of the problem. I sat the other night and I looked at the young staffers that are behind you all, just like the ones that are behind us. And I turned.
And you wonder how they got so good so young.
I turned and I said to my chief of staff, I was in Florida, that the people, and they are great minds, and I don't disparage them, I don't know them, but they're too young for the criticality of what's going on in this particular aspect. Too young in the sense that you now prefer, through your committee, by your 23-17 vote, to bring an absolutely historic matter to the House of Representatives regarding a cabinet official. No cabinet official in the history of this country has ever been held in contempt of Congress. I did not say, nor would I, that there were not many of them who withheld information rather repeatedly in all administrations, probably for all time. But we're getting ready to stain this institution with this particular kind of undertaking. And I for one,
Mr. Hastings, I may say the stain will be on the Attorney General's office for refusing to deliver documents that he knows he could deliver, that he has offered to deliver, but only in return for, if you will, a plea
who was at the
bargain.
White House meeting last night or yesterday? Here again, staff people.
I apologize, but that's all they wanted. That was the request.
Was the Speaker's office represented
Yes.
there?
Two of his
Your
most
office
senior people.
represented there?
Two of my two most senior people.
Can you stand here and honestly, or sit here and honestly say to me that you feel that yours and Mr. Cummings' efforts to get to the bottom of the information that you are seeking has been done on a bipartisan basis?
No, I cannot. I believe Mr. Cummings has not lived up to his promise. I wish he had to the Terry family. I believe in spirit he thinks he has, but in reality, the truth, the full truth, is too painful for, in fact, him to take on his own Attorney General. And I think that's one of the problems that goes on in every administration.
Well, I'll
You know,
tell you
Ms.
this,
Slaughter, before she
Darrell,
left,
You don't know the Elijah Cummings that I know. Elijah Cummings is not a lackey or a minion of Eric Holder, nor am I, or any of us. Just like you, we have responsibilities. But when you and I worked on the Intelligence Committee, we had ideological differences, but we worked on the same matters. And it isn't only the Terry family, it is this entire nation needs to understand the dynamics of what transpired here. We know for a fact that it was a failure, and we know for a fact that Agent Terry was killed, and you have identified some people, some of whom didn't appear before your committee here today, that easily should have been inquired of long before you began investigating the investigators. You have your prerogatives. I think they're mistaken, and I think they're going to disserve this institution.
if the
I yield back my time.
okay.
I was not going to ask any questions, but, and Mr. Hastings brought this up, who gave you the wiretap affidavits? Who turned those over to the?
I'm afraid I can't answer that.
Okay.
And I hope that all the members would understand that whistleblower secrecy, particularly when they are outside of a specific ability to protect, is critical. Agent Dotson, one of our whistleblowers, has been the subject of repeated abuse by this administration or people in the administration. And in fact, there's a current investigation of former U.S. Attorney Burke for possibly leaking information as part of retaliation. So protecting our whistleblowers is critical. Those documents and all the documents we receive, we do maintain secrecy as to the source.
And I've had an opportunity to go down to the committee chambers and read those documents. You know, having served in law enforcement for 38 years and working with the federal government on numerous cases, OCDF cases also, I'm surprised at what I read. I'm surprised that those cases moved forward or as long as they did and continue to do that up until the point where Agent Terry was tragically killed, murdered, along with, like you said, almost 300 Mexican citizens.
Perhaps countless numbers we won't know.
You know, every time in law enforcement, I was chief law enforcement officer for a county. Mr. Holder is chief law enforcement officer for the United States of America. But every time I was presented with a subpoena, unless I went to court to try to quash the subpoena, I had to comply. And I understand the limitations. I understand blacking out specific things in regards to operations, in regards to investigative procedures or techniques. But at the end of the day, I don't understand, I really don't understand why the Attorney General, who I believe probably didn't know anything about this, why he would be so reticent in regards to releasing information that would clearly show that he didn't know. Particularly with all the information that was going on at the time and all the hoopla that was going on at the time in regards to guns leaving America and being utilized in Mexico to keep the drug cartel moving. It's hard for me to understand how it never reached past just Phoenix. Having dealt with the federal government on a number of cases, on drug cases, working with DEA, FBI, ICE, and others, wiretap cases, I'm surprised in reading the affidavits that it didn't move further, at least how it didn't move further. And I guess the biggest question is, obviously, the letter that received on February 4th that claimed there was no gun walking going on, and correct me if I'm wrong, it was 10 months before Justice corrected that assumption.
That's correct.
Do we ever get a reason why it took 10 months before they ever made the confession that, hey, guess what, that memo is incorrect?
That's essentially the reason we're here with contempt, is that those documents we request, a substantial portion of them would be exactly right on that question of between February 4th and December, who knew, what were they talking about, and why, when people we believe were saying this is factually incorrect, this is untrue, why that never bubbled back up to us. We do have at least one piece of information that shows as early as August, they were in a position in which they apparently knew that this was false, straight false, and it wasn't until a few weeks before December that they began working on the operatives for how they walked back from this. We have indications that they were considering walking back only from a portion of it, rather than, and I think it's Stephen Weiss, if I remember, who said, no, we got to do it all. We got to do the right thing. And, you know, there are people that did the right thing in this process, but may have been delayed by 5 or 6 months from the time they knew. And there are people who obviously knew the right thing and were officers of the court and did not come forward. It is part of our investigation, but you hit on something that I think is equally important. You've looked at a lot of wiretaps over the years. We believe, as part of where we have to get at the end of this investigation, we believe that the fundamental rules for actual accountability of reading and understanding, not a summary page, but a wiretap, of coordinating OCDEF so that you understand what some parts of it know and some don't, so that one person becomes accountable for the overall operation, that's lacking, at least in ATF and apparently in all of justice. And that's the reason that even after we do what's right for accountability for the Terry family, we're going to have to present a series of reforms, hopefully ones that will be instituted primarily by the justice itself, to make sure this doesn't happen again. And I know we've taken a long time, but 6 years ago, I did an investigation when I was a minority or majority subcommittee chairman of an organization you might have heard of, Mineral Management Service. And what we discovered was they robo-signed everything they did practically, so there would be initials or signatures repeatedly, but they admitted to us in the investigation that basically they only saw the cover page and signed it. And so you had this look of accountability on oil leases that cost us tens of billions of dollars. You had this whole process of whether you had oversight in the Gulf over the quality of drilling rigs and so on. In 2006, we got a long way down there when we published a good report that said there was problems at Mineral Management. But we didn't take it to the next step. People died. Billions of dollars were lost. America was embarrassed. The oil industry was embarrassed. And lives were destroyed forever. Because in 2006, we knew there was a serious problem at Mineral Management, and we never did enough to try to fix them. Maybe BP wouldn't have happened if we'd seen it to its conclusion. In this case, these are human lives too, and we've got to take it to a conclusion that protects America in a way that I don't believe they're currently protected.
In reading the wiretap applications, I guess I'm confused. I don't understand how whoever read them wouldn't have been concerned with the fact that we're letting thousands of guns walk without any idea where they're going. Well, they had an idea where they're going because some were recovered in Mexico, some were recovered within the United States. But did you ever get an answer as to how that continued on for that period of time, particularly with, it's not like 7 guns walked, 10 guns walked, and we're trying to figure out who the bad guys are, because obviously in wiretap affidavit, they laid out specifically who they thought were involved, and were able to back it up through the wiretaps. and it wasn't 7 guns or 6 guns or 10 guns. It wound up being, in some cases, hundreds of guns in a very short period of time. Did we ever get an answer as to how that continued?
No, sir.
U.S. Attorney's Office is responsible for that,
Yes, sir.
correct? Did we ever get an answer from the U.S. Attorney's Office as to where the ball dropped?
The people most closely associated with it have denied that the ball dropped. The people further away from it have said they didn't know, and that's part of the connect the two that we're trying to get to.
And so I go back to, my initial statement is, I can't imagine as the Chief Law Enforcement Officer under subpoena wanting to negotiate with you in regards to a specific area that you're concerned about as to what happened after the 4th, actually, when you got the letter, to the time they walked that back. Why would they stonewall you on that particular issue if they're clean hands?
I don't know.
Mr. Cummings?
I was sitting here thinking about, I'm going to answer your question. You're going to have to ask it again. But let me say something, because I need to get this off my mind. In my 61 years of life, no one has ever questioned my integrity, and you just did. And if we were in another setting, I would say you should take your words down. I'm not trying to protect anybody, and I resent what you said. I do, deeply.
You said what I said?
No, I'm talking about what he said a minute ago in answer to.
I answered a question.
Well,
as best
and
I
I'm
could.
telling you, you questioned my integrity, and I resent what you said. Now, what was your question?
Well, I can see you were upset and you were stewing over there,
No,
that.
not stewing. It's just that,
Well, I mean, here's my question. You were an attorney. I was
yes, I
not.
am.
I was a cop. But when presented with a subpoena, have you ever been presented with a subpoena?
Yes.
Did you?
But I'm not the Attorney General of the United States, and I'm not the person who asserts certain privileges, as
Well,
Mr. Hastings was talking about.
Does being the Attorney General of the United States preempt him from a lawful request from Congress, a subpoena, to produce documents? Does he have the ability just to say, I'm not going to do it, or I'm only going to do it to such a point as I want to, and after that?
Well, it's not as simple as you're making it sound. When you're asking me for wiretaps, if you're asking me as Attorney General for wiretaps, for things that are going to interfere with a investigation, for, let me finish, confidential informants. So it all depends. Or if you ask me for things that might be subject to executive privilege, that's a whole other thing. So, and I think that's been part of what we've been going through.
Well,
That's a good answer, but I'll give you the other side of that answer.
okay, I'd love to hear it.
All we're asking for is every single responsive document that, in fact, would not compromise an ongoing investigation and would not be part of a court seal or some other prohibition. We can have a discussion with those separately. What the Attorney General has clearly said in testimony and through his employees and himself in that meeting last Tuesday is, no, I'm not going to give you any part of my deliberative process unless it serves my purpose of bringing this to a conclusion. Then I will give you a selected group after you agree to that. Ultimately, it is only that small part. We're not talking about wiretaps. We're not talking about things which a court would object to or that would compromise ongoing prosecutions. We're talking about things which we believe he has every right to give us, but he is saying that when it's deliberative, he will choose what we get or don't get. Meantime, that deliberation was about false statement made to Congress and the period of time in which they debated various aspects of it being untrue and what they were going to do about it. Now, Mr. McGovern objected to the reference to Nixon, but that's the definition of a cover-up. Something is said wrong to send people in the wrong way, and then there's a period of time in which you try to support a wrong statement. All we're asking for, and the reason for contempt is, we were told a lie, we want to know about the deliberation for 10 months between the lie and the truth. And that's the information we seek, and that's the information the Attorney General has said, no, I won't give you because it's deliberative and it doesn't serve my purposes.
One of the things that the Attorney General did say also was that he was protecting institutional concerns. You remember that?
Sure. His
And,
institution has the right to lie and then talk about it, is what he's saying.
You see, this is what I...
Well, let me ask you, do you know what the institutional concerns are that he's trying to protect?
He didn't go into that. He did not go into that.
But you know all we're asking for. The contempt is fairly straightforward here on the rule. It is in fact about documents during this period of time that would be responsive to the false statement made in February 4th of 11 until the time it was retracted. And I will say for all of us, and I know that Mr. Hastings and I had great service together behind closed doors, and we fought together against then the Bush administration when they didn't want to cooperate, and that was hand in hand up and down the dais. If we cannot have access to the information related that is necessary for us to do our discovery because it's deliberative, then in fact we have a closed government system in which we simply give them the money and go away. If we in fact cannot have, when we've been lied to, discovery about it, then where do we go to get the truth?
I thank both of you for your comments. Thank you.
Thank you.
Let me just say that we have 13 votes on the House floor, and I very much hope that we'll have a chance to hear from Mr. Terry's representative, the Dean of the House, Mr. Dingell. And so, Mr. Polis.
Thank the Chair. First question is for Mr. Cummings, and then I'll go to Mr. Issa on it. But on page 12, the contempt citation states, the subpoena was issued following 6 months of constant refusals by the Justice Department to cooperate with the committee's investigation into Operation Fast and Furious. And first I'll ask Mr. Cummings, you know, again, the record shows that prior to the date of the subpoena that had that quote that I just mentioned, the Department had produced over 2,000 pages of documents for the committee, made an additional 1,195 pages of documents available for in-camera review, briefed the committee 4 times, and made 17 witnesses available for transcribed interviews. In your view, does that constitute, quote-unquote, a constant refusal by the Justice Department to cooperate with the committee's investigation?
I think the Justice Department has cooperated quite a bit with us. And again, as I said earlier, I think there were times when there were issues over certain types of documents that were subject to, you know, like that he could not produce because they were, like, say, wiretap applications, things of that nature. But I think they've worked pretty hard. Keep in mind, they had to go through millions of emails and thousands upon thousands of documents, and they actually had to go to 240 custodians to get the documents, and they made 42 presentations to our committee of documents. So that's quite a bit of work in a little bit of time.
Thank you. I asked the Chairman if there might be a way that I can see the witnesses, or can the camera possibly be moved?
There you
go.
go.
Okay. Thank you. Okay, that's better. There you are.
Very powerful.
I asked the same question to Mr. Issa with the following, you know, lead-in. Again, the words matter. You know, exact words matter. We're in the business of words. We're passing words. This is a specific contempt citation. It says constant refusals to cooperate, constant refusals by the Justice Department to cooperate. It seems to me what you're talking about here may be appropriately conveyed as a partial refusal. It may be an incomplete compliance, but I find it difficult to see how the words constant refusal are consistent with the cooperation that occurred, albeit in your eyes insufficient.
No, I agree with you that that's a point that needs to be clarified. Constant in some areas, cooperative in others. And as we narrowed from 22 areas, of which at least 10 were never complied with at all, down to this one, we narrowed from 10 places in which there was 0 compliance to 1. The fact is there were 10 places in which there was 0 compliance. So you're absolutely right that you could say, well, they gave us all or partial cooperation in, let's just say, a dozen areas, while giving little or nothing in the rest. Is that partial compliance? And I think you could have a semantics argument. In this case, the contempt is about one area in which there has been zero cooperation and zero production.
The contempt citation also states very specifically on page 39, quote, "To this moment, the President himself has not indicated he is exerting executive privilege," end quote. I would ask, again, we'll start with Mr. Cummings and then go to Mr. Issa, isn't, in fact, the President's assertion exactly the way that previous presidents have always asserted this privilege? Is that correct?
That's correct.
And I ask Mr. Issa, again,
I'll clarify it.
History.
You're reading a pre-amendment. We amended that at the markup.
Okay.
So it actually doesn't say that.
Okay. Do you have
You just have an earlier version for some reason. My staff informs me.
There you go. Well, again,
but understand that the part of the problem is we received, at the moment the markup was to begin, the executive privilege letter, if you will, as part of a letter from the Attorney General.
Yeah.
And that was untimely, to say the least. But rather than allow it to be like a death row inmate not wanting to have 11 years later an execution, we worked during the markup in order to amend appropriately what you now see.
So just my final set of questions here for Mr.
Let me
Ice.
just say this.
Yes, Mr.
My
Cummings.
staff tells me that they rushed so quickly trying to make the amendments that the information is still in the document.
Yeah, and that's the version that I had to study last night. It's possible it has changed.
Unless it's changed overnight.
Probably going to the floor. It's, again, this is all happening very quickly, and that's a whole other matter why we're not having a proper vetting and discussion. My final set of questions, first to Ms. Issa, do you have any evidence that the President of the United States knew about or authorized gun walking?
We have only two pieces of information. One, the assertion of executive privilege in a way in which we cannot be sure whether the President is asserting his own knowledge or the deliberative process that up until now we believe is the Attorney General's assertion. And that's unclear, so we'll just leave that one alone. The second one is we do have evidence of emails that went from Phoenix to a member of the President's national security team, and that has been a situation in which the administration has been unwilling to make that individual who is the recipient of the emails or the emails in their entirety available to us.
Yeah,
but to answer your question, as I did on Sunday Talk, which is where that question came from, the answer is I have no specific knowledge, nor are we looking to the President. We are looking to the truth on behalf of the Terry family, and that's why we want the documents that we've asked for.
And I asked the same question with regard to the Attorney General. Do you have any specific evidence that the Attorney General knew of or authorized?
During the inception and the participation through the death of Brian Terry, we have no evidence, nor do we currently have strong suspicions. We, just the opposite, have a number of people, including Lanny Brewer, who should have known, whose responsibility was to know, that is part of our ongoing figure out who's responsible and where the wheels fell off of the appropriate cart.
But Mr. Polis, we are now, I hope you listen to what he just said, but we are now about to fine in contempt the Attorney General of the United States of America after you just heard that.
Sure, for what he said he wouldn't do.
Well, hopefully we are not about to. I certainly prevail upon the wisdom of my colleagues, to consider this motion and come down the right way and on the vote on the floor.
It's not for what it's not for what the attorney knew about Fast and Furious. It's for the Attorney General's refusal to provide the documents lawfully requested under.
Well, again,
that's what contempt is.
Well, there we go. There we're going back again to that initial language. I think even you are not asserting a complete refusal. You're citing incomplete cooperation.
As to the period February 4th to December, there is a complete refusal, and now on top of that, an executive privilege claim. As to the narrow subject of the contempt, which is limited to that, Yes, there is a complete
I mean,
refusal.
what of the, one moment, but what of the 2,000 pages? What of the 1,100 pages that were reviewable? What of the 17 witnesses? I mean, I don't see how that can even be
I don't-
reconcilable with the term refusal.
Substantially, none of them, if not absolutely none of them, cover the period February 4th to December about the false documents given to us.
Let me go to Mr. Cummings on that before I go to Mr. Hastings.
I'm sorry, what was your question?
Oh, I was asking about again, have you found there to be at least some degree of cooperation? Again, reasonable
Yes.
debate whether there's been enough. Is there some degree of cooperation?
Yes, there have been some degree of cooperation.
Okay. Ergo, not a refusal. Refusal is a complete lack of.
There is a refusal as to the area for which we seek contempt. You know, you can answer everybody's questions but one area and then tell the judge, I'm just not going to give you that. That is contempt. And that is why you have a very simple question before you. All the extraneous information that we've helped educate you with here today has absolutely nothing to do with the narrow question of, from the time we were lied to for those 10 months, those documents.
I yield to Gentleman
Is
from Florida.
there an Inspector General's investigation ongoing, and when, if at any point, if you know, the report is?
Mr. Hastings,
to issue?
they're on their second Attorney General in over a year. So quite frankly,
Inspector General,
Inspectors General,
right.
they're on their second Inspectors General. They had 10 months, I believe, of the predecessor and now 2 months of the new one. And to be honest, we don't know when or if it will happen. What we do know is, in fact, that the Inspectors General was given 80,000 pages, and we've been given 10% of that. The Inspectors General may not ask some of the same questions. Certainly, the February 4th to December apparently is not part, in other words, the false statement to Congress is not part of that investigation as far as I know.
And so how do you sum up the Attorney General's responsibilities to the IG versus your committee?
Yeah, well, he seemed to be more responsive to the IG by far than to us.
Would you not allow that is a part of his responsibility in light of the fact that he's the one that stopped Fast and Furious and ordered an Inspector General?
Brian Terry's murder in a canyon in Arizona stopped Fast and Furious, from what I can tell. And the Attorney General referred to the IG more than a month after, I believe, approximately a month after Mr. Grassley, Senator Grassley, sent a letter. So the Inspector General's request appears to be prompted by Senator Grassley. The concern by the Attorney General appears to be as a result of the inquiry after Brian Terry was killed. That seems to be the indication, but I can't be sure.
Okay. I thank you. I'll yield back the balance of my time.
Thank you, Mr. Chairman. I have a question of Chairman Issa. I want to make sure that I understand this. I have a document here that says that there were 140,000 pages of information.
Is your mic on?
Relative, it says approximately 140,000, relative to this Fast and Furious. Is that true?
Yes, that's what the Attorney General had said in
You've
previous testimony.
gotten 7,600 pages.
That's correct.
There was an offer, it sounded like, as late as yesterday for another 1,300 pages.
No, the
Okay,
1,300
so
was
we'll
a
stick with this.
hypothetical. The offer apparently is less than 300.
Okay. So I'll stick with the 7,600. If I owed you $140,000, would you accept for full payment $7,600?
If I thought it was your last 7,600, yes. Otherwise, I'd like to get a fairer share.
I don't blame you.
And we've always been willing to compromise and to do in-camera review to limit the discovery and the burden of it. We want to get to the truth, but we know that there's much of the truth contained in those 140,000 we've been denied.
Well, if it reversed, I wouldn't be as merciful as you're being. I will say this, though. Let me just ask this final question. If 132,400 pages were accessible to you before the vote on any of these issues, would that suffice what you're asking for? Would that be the solution that Mr. Woodall said? Where do we go next? Would that suffice, what you're asking?
If those documents were made available to the committee, it would cause a postponement, and if those documents were as they asserted to be, it would end this standoff altogether, I have no doubt.
Thank you.
Gentlemen, thank you very much for being here. We appreciate your
Can I
testimony.
state it here,
We're
the
very
Dean?
happy to recognize the distinguished Dean of the House, our good friend from Michigan, Mr. Dingell, who I know is Mr. Terry's family's representative. Please, Mr. Dingell, without objection, any prepared statement that you might have will appear in the record in its entirety, and we welcome your summary.
Thank you, Mr. Chairman. I appreciate